SJC-10251, Commonwealth versus a juvenile.
Good morning, Mr. Chayton-Pollock.
Good morning, Madam Chief Justice and Honorable Justices. My name is Sharon Chayton-Pollock. I represent the juvenile with Beth Eisenberg. We have 4 main points to make for you here today. First of all, Chapter 265, Section 47, the Probation of Sex Offenders statute, which mandates GPS monitoring for any person placed on probation for a sex offense, is not applicable to pretrial juveniles on supervised conditions of release pursuant to Chapter 276, Section 58, such as the juvenile in this case.
This is going to show my ignorance about juvenile procedure, but when a juvenile, when a complaint issues against a juvenile, what's the process? Is 276, Section 58 what governs bail or release? Or is there some special statute that does it? I couldn't find it, but I didn't know if there was one.
No, my understanding is the same as yours, that Section 58 equally applies to juveniles. For example, juveniles often have petitions under Section 58A filed against them pretrial also.
And I know they have bail reviews. But so when your client was put on probation, that was just pursuant to Section 58 and nothing special about it. There's nothing particular about the fact that he's a juvenile. I mean, he could have been 22.
First of all, we do contend that he is not on probation, that probation is a status that is separate and distinct.
Sorry, I wasn't disagreeing with you.
Oh.
But I mean, he reports to a probation officer.
He does. He is supervised by probation with certain conditions of release that were determined by the judge at a hearing. But what happened in this particular case was that conditions were agreed by the parties, first of all. Afterwards, after the imposition of some conditions, according to the docket, the judge then added GPS monitoring as a mandatory condition of his release prior to trial. Now, which statute that is under is a matter of contention in this case, because a document is used by the courts and was used in this case for the memorializing of the conditions, which says Section 87,
right,
the probation statute. We contend that the document is a vestige of the time prior to the amendment of Section 58, the bail statute, which now has as its last sentence of the first paragraph that the courts have the power explicitly, which they did not have prior to 2006, to impose conditions of release on a pretrial individual. Inherent in that is the ability to supervise those conditions, otherwise they would be unenforceable and somewhat meaningless in certain cases. And so we contend that he is on such conditions of release pursuant to Section 58 and not 87, because the amendment relieved the courts of the need to look to Section 87.
Let me ask you this, though. I'm a little confused about the sequence here. I take it your client signed an agreement with respect to pretrial release.
He did.
And did that include agreeing to GPS monitoring?
Well, it did. However, the order
so why is this a problem?
This is a problem because it's clear from the record and in the text of the trial court judge's order that denied the juvenile any relief from GPS as a mandatory condition, that the judge felt constrained by the probation of sex offenders statute that we are challenging today, which is 265, Section 47, to apply mandatory GPS monitoring to the pretrial juvenile because it contains the word shall. He felt that he was constrained. It would cause
so it really comes up, so in other words, when the condition was originally part of this pretrial probation agreement of some sort, it wasn't imposed as required by 47. Is that what you're saying?
Initially,
When the juvenile sought relief from the GPS condition, the judge said, well, I have no power to relieve?
It wasn't
first-
initially imposed, was it?
the docket, if I could draw your attention to the dockets in this case at Record Appendix page 17, indicates that on the same day, several different entries occurred, several separate orders occurred by the trial court judge. I believe there were 4 in total. The first of those orders memorializes what's described in affidavits and the petition by initial counsel as an agreement by the parties that did not include GPS.
Okay, so
And the
first-
judge did not impose GPS on round 1. However, that was prior to any signed documents that are in the record. The first signed document memorializing the probation conditions in the record, signed by the juvenile, does incorporate GPS because that was pursuant to, I believe, the 3rd order by the judge that day, after the judge had decided, actually, this person needs to be subject to this statute. And then later on, his reasoning became clear. His reasoning was that he felt he was constrained.
Okay.
Did the order change from step 2 to step 3 to incorporate the existence of the statute into the order?
The existence of the GPS statute?
Yeah.
Yes, it did. I believe
Okay.
the 3rd order on January 23rd states, and GPS. I think that's the extent of it.
Do you have a reference to the page of that 3rd order?
Record Appendix, page 18.
Oh, isn't it 23?
That's in the docket.
Isn't the, I'm sorry, this is an order you're talking about, or the,
That's the docket entries. Is the order itself in the record?
The order of, there is no order of conditions signed by the judge in the docket, no.
Okay.
There is an agreement
How do
only.
we know that this was done after? Because everything's on the same day. I'm confused.
In part, it's the order of the docket, and in part, it's the other documents in the record, such as the petition written to the single justice written by former defense counsel, which memorializes the order of events as I've just related.
Okay.
If I might,
Excuse me
Well,
again.
okay, on Record Appendix 23, it says, it's somewhat ambiguous, paragraph 4, on January 23rd, the Commonwealth and the defendant agreed to terms and conditions, blah, blah, blah. The agreed terms did not include the wearing of a GPS device, so says the petition. And then it says the defendant was then informed by the trial court judge he would also have to wear a GPS monitor, to which at the time the defendant did not object. So, and then later in the day, after meeting with probation, the defendant was informed he would, in addition to wearing the GPS device, remain in his home. But it appears from the petition that this, it just says the defendant was then informed by the judge he would also have to wear a GPS monitor.
correct.
And he didn't object. So how do we know that this wasn't one of the, it would appear that it was one of the terms to which he agreed.
He didn't believe he had any control over the matter at that point. An objection.
Well, how do we know that?
An
that's-
objection would have been futile because the judge at that time required it as a mandatory condition, not as a condition based on the hearing.
so would you concede that if in fact it was not, if the judge felt he had discretion, but simply imposed it because he felt it was appropriate, that that would be okay?
If the judge felt that he had discretion, that would be under Section 58, not under Section 47 of 265, the probation of sex offender statute. However, in the exercise of that discretion, because this is not a regular condition, this is a condition that burdens fundamental liberty and privacy rights of juveniles, there must be a specific constitutional analysis performed by a judge in a hearing if he wishes to impose this on a juvenile who is pre-trial. He would have to first
But he
consider
didn't
whether
have
there's
to
a...
consent to it.
I'm sorry?
But the juvenile did not have to consent to he didn't have to consent to the whole thing.
Well, in this case, he did. I believe that it's a Hobson's choice to say you can either consent to this or go be held in custody.
Right, and I guess my
This is
question goes,
pre-trial, this is pre-trial,
Pre-trial.
correct? So this is before
Pre-trial.
there has been any adjudication
Correct.
of guilt or innocence.
Correct.
and my
So
question,
essentially, you're saying that you can perhaps have a dangerousness hearing under 58A.
You could have a dangerousness hearing or simply a hearing under Section 58 as a normal bail hearing would be. However, right now the statute's language precludes that, which is why the judge felt constrained, because
You mean Section 47?
the probation of sex offenders statute, Section 47, would preclude that by its language, which includes the word shall, if a judge feels that that statute applies. We argue that that statute is simply completely inapplicable to a juvenile, to any juvenile, because it is punishment.
And my question to you is, let's assume we agree with you. Could, however, the judge have imposed this condition under Section 58 as a condition of release because he's charged with, I don't know, 3 counts of rape, and there was significant concern about where he goes and where he shouldn't go?
With an individualized hearing that complied with due process of law and a constitutional analysis by the judge of whether there's a compelling governmental reason to infringe on this particular juvenile's fundamental liberty and privacy rights and reputational interests by using GPS.
Okay.
But yes.
And that the judge must then consider if a shackle like this is excessive to that reason, and whether the reason is narrowly tailored at all.
But at the end of the day, an individualized hearing could result in the imposition of GPS monitoring for this juvenile.
Under these circumstances, under this analysis, we contend, yes.
Okay.
Yes.
Thank you, Ms. Chayton-Pollock.
Your time is up.
Thank you.
Good morning, Ms. Eisenhower.
Good morning. May it please the Court, Rachel Eisenhower for the Commonwealth. On Record Appendix, page 41, there is a February 8th, 2008 order from the Court. I see you're aware of it. That indicates to me that the judge was acting pursuant to Section 47. The fact that he felt Section 47 applied at all indicates to me that he believed this was a case where the individual was on probation rather than on some condition of release. I believe that the
I perfectly understand how you get to those points.
yes.
The question, I take it that the question that we have to consider is whether or not we're under 58 or 47, and you're saying we don't even have to get to that because he was proceeding under 47.
I believe that you do not have to reach the issue of how he got to probation because he was on probation because under Commonwealth versus Taylor he had both conditions and supervision, which to me is the cocktail that creates probation under the law.
So, Ms. Eisenhower, do you say that any time a person, juvenile or adult, is released with conditions, but there's no Section 87, maybe, formal agreement, that this statute would apply? A pretrial?
Not if they're not required to be supervised. They're under.
But every time a judge says, and you are to, you're to report to the probation officer, you're to call the probation office
Yes.
3 times a week.
Every time you've required supervision by probation, I believe that that's
Pretrial.
probation.
Every adult, everybody is
And,
covered.
Part of the reason that I believe that that's the interpretation that's both intended by the legislature and intended by the probation department is there is a memorandum in the record appendix of one of the other cases from probation detailing that is their impression too.
No. I understand probation's taken that position. Yes. You're not representing probation here, right?
Yes. I believe that this was pursuant to Section 87 in this case.
87.
Yes. I believe that the release was, as on the form, pursuant to 87.
And then in answer to Justice Botsford's question, not asking what the probation department's interpretation is, your interpretation is that if you have supervised release under Section 87, then you must be subject to Section 47.
Yes, that is my understanding.
Okay.
So your understanding of the interpretation of Section 47 is that someone who is released pre-trial, pending trial, with conditions and supervision, has been placed on probation for an offense.
Yes.
For an offense.
Yes. And
Has been placed on a term of probation for an offense, as opposed to simply being released with terms pending trial.
that is the most difficult part of the language because the
It is.
plain meaning of the word offense could be interpreted to be a convicted offense,
Mm-hmm.
and obviously that's the problem. I interpret offense to mean being charged under a statute, which is why I think that the application of 287 applies. Chapter 276, Section 87's use of the word probation in the pretrial context, and in conjunction with Section 265, Section 47, the GPS statute's use of the word probation, indicates to me that they should be read in conjunction, and it has to apply pretrial. It's the plain meaning of the legislature as far as I can tell.
So
Does it matter that this is a juvenile?
I don't believe so. I actually think,
How old is this juvenile?
at the time of the first offense, he was 10 and a half. I believe he's maybe 13. He was born in 94, so
So this is a child,
Yes.
14.
unquestionably a child.
Yes.
He turned 14 in December, I think.
Yes, so eighth
But
grade.
he was 10 and a
ninth grade
half
age.
when this began?
He was 10 and a half when the first offense was committed. I believe that the charges were brought maybe 2 years later.
And it doesn't matter?
As a constitutional matter, the state has even greater supervisory powers standing in loco parentis with an 18-year-old. I mean, the juvenile death penalty cases out of the Supreme Court show that we don't hold juveniles accountable for their actions because of their underdeveloped senses of right and wrong, or senses of self-control, and that same principle operates to their detriment in this case. Just as we punish them less, so too we have the power to monitor them more. And if this court has no further questions?
Thank you.
I guess, and I know it's not this case, but I'm just trying to understand this as a practical matter. So in your view, any adult charged with a sex offense who is released and may have, apart from this statute, has to call once a week to the probation department. That person is subject to Section 47.
Well, your question goes to the interpretation of the 2006 amendment to Section 58, which hasn't yet been interpreted by this court. When that is interpreted, that may change my opinion. If it's interpreted that is conditions of release, the Commonwealth versus Taylor case clearly stated that there were two different kinds of release pretrial. There was probation, and then there was conditions of release, which were unsupervised and not intended to be considered probation. But we have a system now where you can be released on what are called conditions of release, but then they're supervised. So in my mind, we've muddled those two categories, and I don't know how we're going to unmuddle them in a way that makes this statute clear. Therefore,
Well, there is a way, of course. Interpret the statute to apply to post-conviction probation.
that is one way, Your Honor. I am suggesting that the legislature's intent was to have a uniform system of monitoring for the ease of probation, that just as they have a duty to monitor anyone under their care, so too they have a duty to do that in the way that...
Do you point to anything other than your interpretation of the language, that this was intended to apply to people on pretrial release pending their trials?
Just the plain language, Your Honor. And of course, the memorandum of probation is their opinion. But
I did see that. Now, that's attached to another case?
that's attached to the Raposo case.
And do you agree with that memorandum? I take it you're not agreeing, actually, in your brief in the Raposo case.
The memorandum is what it is.
Okay.
You're very discreet, Ms. Eisenhower.
Well, if the court has no further questions, then the Commonwealth would rest on its brief in this case.
Thank you, Ms. Eisenhower.
SJ